Lawsuit update. The Trump administration is determined to have CHNV parole terminated. Guys, last week, the Trump administration filed an emergency filing with the United States Supreme Court. And in that filing, what they are asking the Supreme Court to do is to reverse the federal judge in Massachusetts, her order, Judge Tawani, to reverse her order that blocks the current administration from ending CHNV parole. Now, guys, let me explain to you briefly what is this whole fight about, at least on paper. On the one hand, the Trump administration is saying when the Biden administration created the CHNV parole program, granting hundreds and thousands of individuals parole categorically, they're saying the Trump administration under immigration law did not have that authority. And that is, parole is to be issued on a case by case. Now that we're in the Trump administration, DHS Secretary Noem, she categorically terminated CHNV parole. A lawsuit was filed. That lawsuit ended up in front of Judge Tawani in Massachusetts. Now, what Judge Tawani ruled is that DHS Secretary Noem, she cannot categorically terminate 500 plus thousand parolees that have been granted. But here's the thing, guys. The government is saying, Judge, how can you say that? Biden administration created the program categorically. DH Secretary Noem under the Trump administration ended it categorically. Why are you only looking at what DH Secretary Noem has done by ending the program? Because the judge's order specifically provided that before this current administration can end it before they can end it, they can't end it categorically, but before they can end one's parole, they have to end it on an individual basis. That means case by case. Now, what the government has said is that if the government has to do that on a case by case, it would make it where individualized parole determinations for every one of the 500 plus parolees, it would be a colossal undertaking. Basically, the government wouldn't have the manpower, the time, the resources to do it one by one. And so this one is going to be quite interesting how the Supreme Court rules on this, because on the one hand, this administration is saying Biden created a program categorically where you let people in by the hundreds and thousands all at once without looking at it on a case by case. That's the argument the government is saying. While on the other hand, the government is saying if Biden could create it categorically, the Trump administration can end it categorically. And so it's going to be interesting what the Supreme Court ends up ruling. Now, the next court deadline related to this is that the plaintiffs have until next week, Thursday, 4 p.m., to provide their response to the government's emergency filing. So this one is one we definitely have to keep our eyes on. In the meantime, what should CHNV parolees be mindful of and consider, and definitely also working with an attorney? And that is, if you have another lawful pathway that you are eligible for, work with an attorney to undertake whatever steps you have to take to submit whatever additional pathway you are eligible for. In addition, some CHNV parolees also have temporary protective status. And if you do, but you haven't applied for an employment authorization pursuant to your temporary protective status, work with an attorney considering filing that as well. CHNV is still very much on shaky grounds, guys. Please work with an attorney concerning your particular immigration matter if you are a CHNV parolee or if you have a loved one who holds parole pursuant to CHNV. Thank you so much for watching. I will see you in the next one. Bye-bye. Welcome to McKinney Immigration Matters TV. I am Andre McKinney Dorval. To our subscribers, I want to thank you for your support. And if you haven't subscribed, we welcome you. I want to thank you all for your likes, your shares, and your comments. You guys are truly the best part of our channel.